You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. Our guest today is Zoe Littlepage, and I've admired Zoe's work for a long time. And today I'm getting the chance to interview her and have her on the podcast. And Zoe, thank you so much for taking time.
Of course. Thanks for having me.
My pleasure. For folks who aren't as familiar with your career and background, can you just bring us up to speed a little?
Sure. I was born and raised in the Caribbean, and I came to America to go to college and then law school, and I started working as a defense lawyer. When I came out of college and law school, I applied to all the plaintiffs' firms that there were in Houston, and I didn't get a single interview. But I got like 5 offers from the 5 biggest firms in Houston because I had good grades, but I did not want to be a defense lawyer. But I thought, okay, I'll try it. This is what I've got offered. I went to it, and exactly a year and a day later, I left and went on the plaintiff side. I finally got my in on a plaintiff's firm, and I never looked back. I realized pretty quick I was not defense oriented. I was very much, my heart was for the people and my heart was for the injured. And so I chose plaintiff's work, and I've had my own firm since 2 years out of law school, and it has been a glorious career.
Zoe, how's your experience growing up in the Caribbean in terms of how it's influenced your approach to law?
I think I come from a culture that's very joyful. We dance, we sing, we are very family oriented, we are very close knit. And so I can really understand and have great empathy for people who have lost the joy in their life, which is what happens when you're catastrophically injured. I mean, you're going to work one day, or you're walking down the street, or, something really unexpected happens and your life suddenly goes, a complete turn. And you've lost a lot of the things that were really important to you. And it could be things like you were a quilter and your eyesight isn't good enough now and you can't quilt. It could be a sport. It could be just spending time with your grandkids. But I think my background really helps me understand the value of those things. It's not just the money. It's not just you can't make a living anymore, although that is catastrophic and terrible. But it's all the little things that bring people real fulfillment. And I think it's helped me present that to the jury, have the jury sort of empathize and understand what my client's going through.
And so that was my next question. The techniques that you've developed and just what exists inside of you that helps jurors be able to properly value those damages, those harms, those losses in the way that you have throughout your life.
Well, I think you have to understand. I mean, I know we're here to talk about storytelling, but I think a lot of telling your client's story is not just liability, where we focus a lot of energy because we know we can lose on liability and we can lose on causation. And often lawyers don't spend quite as much time on damages because they think sort of, the injury itself will carry the day. And you really should spend just as much time developing your damages story. And that is your visuals, going back through, going to your families, to your client's home, sitting in their home, meeting their family in their environment, going through their picture books, looking at their old videos, looking at their bedroom, their living room, their garden. I mean, this person could be an amazing gardener and it never comes up in conversation. They could be, an amazing painter and it never comes up in conversation because they just paint the stuff they like and they hang it on their wall. So really thinking about how can I step into someone's life and tell their story for them. I mean, what an honor we have as trial lawyers that someone who's really injured chooses us to tell their story, to advocate for them, to be their voice. And what I would really emphasize is be the best, kindest voice. And that is really getting to know your clients and spending as much time understanding what really changed in their life. What are they, everything about their damages, as opposed to just the words, tinnitus, loss of vision, a limp. What does a limp mean to that person? Were they hikers? Were they athletic? Were they someone who loved to walk the dog? Does the limp really change their joy?
I love that. We had the experience recently at a client's house, and low back injury,
back surgery, wonderful guy. And the thing that we would have never known, it never came up in conversation, was in their backyard. They had some firewood, but the firewood, you could tell it had been there a while. And I just said, "Hey, Matt, where'd that firewood come from?" He was like, "Oh, we had a tree at the back of the property, you know." I said, what was cutting the firewood all about? He was like, "Oh, for our family fires." That's the time when me, the kids loved it, wife loved it. We get around, and he pointed a little outdoor fireplace they had. This is one of the places that we'd sit around. And I said, I see the piles getting kind of low. He's like, "Yeah, man, I haven't chopped wood in a couple of years." Again, not something that was ever going to be
Discussed.
talked about.
Mhm.
And it wasn't just the firewood, it was what it symbolized. It was what it meant to him and his family.
It's also a story. And we can use words like it's painful, it's sad, but those don't land in the hearts of people. I mean, you can tell me you're having a tough time, and I can feel that, but until you tell me a story that makes me feel your tough time, and a story like that lands, right? Now, when the jury goes back in the jury room, they're thinking about that firewood and that, gathering of the family around the fireplace and how important it was for him to be the person that provided the wood. And it's those stories that create visual storytelling, whether it's actual visuals, a picture of the fire pit, or just the words that you use to describe the story. So much more powerful. And embedding, remember, our jurors don't deliberate at the end of our case. They deliberate at the end of the defense case. So we've got to tell stories that will last through the defense case and all the way into deliberation. We've got to really land in their hearts.
That's so well said. So when we talk about visual storytelling, um, you talked about spending time with clients, spending time in their homes, getting the visuals. Can you walk us more through that process, through your approach to storytelling and specifically to visual storytelling?
I'm a visual learner, so I really can't even tell a story without visuals. I mean, if I'm sitting at a coffee table telling someone something, I take up a pen, I'm drawing on the napkin, right? Because that's just the way my brain works. 60% of your jurors, their brains work the same way. So I meet a lot of lawyers who say, "Well, I'm just not visual." Well, you have to learn because your audience is visual. It comes a little easier for me because I do see things visually. That's sort of the way I look at the world. And so I know it's more of a struggle for someone who is an auditory learner and doesn't see really the value of the visuals. But even the most simple visual, a flip chart where you just write, ABC company did wrong, they caused harm, my client is very injured. Our our cases, liability, causation, damages. Even if you just wrote that and put it on a flip chart in front of a visual learner, suddenly the whole case has format, has a roadmap, has a framework. So visuals don't have to be the best, most beautiful photograph or the greatest animation. I always teach lawyers thinking visually is thinking, how can I embed my message in this juror? And for many jurors, it's organization, using flip charts or timelines to really embed the information in a logical, visual way. And sometimes it is beautiful pictures. It is, the dad holding the little girl when she was born, and that dad will never walk her down the aisle. It is sort of the emotional visuals of the right photograph, the right video, the right, um, you have a picture of someone's garage 2 years before they were injured, and it's immaculate. They've got their bikes, they've got their golf clubs, they've got their paddle boards. That garage tells you everything about that person's life, the joy they have with the outdoors. And then you come back after the accident and you open the door, and that garage is just a hoarder's garage. It's full of boxes and junk. They've given up. They've given up on that sort of joy that they had. So those are beautiful images that are really powerful. Um, and so I think to think about visual storytelling, it's very broad, it's very wide, and honestly, anything is better than nothing. For a visual learner, even if you're struggling visually and you only give me a couple words on a flip chart, you give me a few images, it is better than none. So for all the non-visual lawyers, it's just a cop out to say, I don't know how to do it, I can't do it, because you are missing such an opportunity. It doesn't have to be all bells and whistles. It doesn't have to be the expensive, animation that reenacts the whole accident, although those are great. But just the old pen and paper, and you sit and you just talk. That's really hard for the modern day listener. And we know now that more and more younger jurors, because of the overstimulation of TikTok and, Instagram and the constant flurry of new images, their attention span is getting shorter. And without visuals, they are very inattentive. So you've got to play the game. And the game is telling your client's story, being their advocate in a way that lands with the entire jury, including your visual learners.
And so what have you found? Because you've practiced and tried cases in a number of different jurisdictions. In terms of any type of consensus, best practices approach when it comes to visuals and openings, visuals that judges have allowed you to use in different jurisdictions, any tips there for people, again, who practice in different parts of the country?
Yeah, I thought about it. I have never been in front of the same judge twice. I've very rarely even been in the same courtroom, because we have tried cases all over the country. So when I walk into a new case, I'm walking into a new jurisdiction, a new set of local practices, a new judge I've never met. I really try to start using visuals early, even in pretrial, even if it's just handing up a chart to the judge, or handing up, something, a very simple image, a simple picture of the intersection, because immediately I know if that judge is a visual learner if they pick it up and read it. Okay, I kind of got them. They know the importance of visuals, but so I think you start early. I think you bring a blow up to a motion for summary judgment hearing. I think you hand something up to the judge in pretrial just to get the judge used to the fact that you're going to be visual. And then I think it's your job to push the envelope. I give all of my slides to the other side ahead of time, except for my cross-examination slides. But I give my opening, my closing, my direct, I give them all. And I put in stuff that is prejudicial and inflammatory, so that I have something to take back out when they go and fuss to the judge. So, if I give them 100 slides, I know they're going to fuss about 20, and probably 10 of those I don't care about. I'm also really willing to change it. Okay, I try to sit with the opposing counsel first and say, what do you not like about it? Do you not like the image? Do you not like the words? What words would you agree to? And then if all that fails, and the judge, and there are some that come out and say, if you don't agree, no visuals, pull out your pen and go to a flip chart. I mean, no judge will really shut you down from writing a few words on the flip chart. But to do an entire opening with no visuals is really unpersuasive. So even if the judge takes away your projector and all of your slides and says none, pick up a pen and go to a flip chart and at least write out some frameworks so the jury has some idea.
So when it comes to slides, be it PowerPoint, Keynote, or any other presentation software, some recommendations, best practices in terms of information on slides, less is more is less.
My absolute mantra is one slide, one image, one phrase. I'm not even giving you a sentence, a phrase. Every slide should be on its own, very clean, with an image and a phrase. Or if you don't get to use an image, just a phrase. When you have these bullet point slides where there's, all these little tiny letters coming up, and they're coming up all the time, and they are terrible. And the moment a defense lawyer puts that up, I think, okay, I'm winning the visual game, because the jury just immediately stops listening. They start reading. What's written down isn't exactly what you're saying. So they then disconnect with what you're saying, and they start reading the minutia. They get lost in the minutia. So that is an ineffective visual. If that's what you're doing, don't do it. Don't do visuals. Just a single word, a couple of words, Try to make every slide with a visual, whether the background is a visual or whether there's some sort of image in the slide, and then a sentence or a phrase. You can have 450 slides in an opening statement if you've got a clicker. You're just clicking through them. The other thing I would say is, although all these clickers have a button where you can press and the screen goes blank, goes dark, I actually build into every PowerPoint a blank slide, just a slide with black. And it's at the end of every point. So if I'm going to use 6 slides in my first point, I then have a completely black slide. When the black slide comes up, I know the jury has nothing to look at. It gives them a chance to pause and breathe. It gives me a chance to pause and breathe, and also to look at them and see if they're with me. Do I need to reiterate something? Do I need to emphasize something? Do I need to go back over something? Because the blank slide says that point's over, she's going to the next point. And the jury very quickly understands it, and understands really within the first hour of trial that that's how I build my slides, is that I build in a lot of pauses, a lot of blank slides. And so my slide decks are really long and really big, but I can move through them very quickly with my clicker.
And so I think I probably know the answer to this, but in terms of building these slides, building these decks, be it for open, various examinations, close, when are you starting that process, and how are you deciding what to add, what to take away as the case progresses?
I start from the moment the case comes in. I mean, the moment the client comes in, because again, I'm visual. I can't see her case without building the visuals. So I'm immediately putting in the construction site. I'm immediately putting in her medical records. I'm immediately putting in her x-rays. I'm immediately looking at the flow of that. I also want, I mean, opening should be a roadmap. So your opening slides should be slides you're going to use all through trial. It shouldn't be a completely different set. You know, my opening statement is designed that I have put in there the key slides that each expert's going to use, that I'm going to use on cross and I'm going to use on direct, the key damages. I mean, I'm really trying to make opening be a trailer. And you know what's really sad is sometimes you watch a trailer of a movie and then you watch the whole movie and something from the trailer isn't in there and it bugs you. Right? It's like something was promised and it's not delivered. So you know, if you have a whole bunch of slides in your opening that you're not using at some point in trial, you probably don't need those in opening. You want to really think in your opening of your story message. And then you pull out all those slides, because I'm telling the jury in opening, you know, cases are like jigsaw puzzles. You know, the evidence doesn't come in exactly in the right flow. Some witnesses can't come the days I want them. You're going to have to take all these little pieces of evidence and put them back together and create the jigsaw puzzle. And so my opening is all those pieces. And I want each of those pieces to come back in trial.
Right. So on that front, are you also saving some other kind of good nuggets along the way that aren't included in your opening? I get the idea of what's in your opening is going to be shown later, but some of these additional points where the case doesn't have kind of the, like what they feared in the movie Patton was, you know, they were concerned that the opening speech from George C. Scott was the apex, and from there it was going to go down. It didn't. It ended up being a, you know, great film. But are you saving additional pieces that aren't going in opening to keep the case kind of building and getting better throughout?
Yeah, and absolutely, because I very seldom show much of the good hot docs in opening. I think you showing a document, the jury didn't really trust you yet. They're not sure exactly where the document comes from. It takes a long time to set it up. They've got to read it, and you lose the punch. So I will tell a jury, look, you're going to see 10 times this company was told this product was bad and they had an opportunity to fix it and they didn't. But I'm not going to go through all 10. I may have a visual of 10, like 10 fingers or, you know, 10 stop signs or 10 red flags. And then each time as an expert or a witness brings in one of those 10, I'm going to have the same flag on the screen, and the flag might say 1 or 6 or 8, you know, as I build my evidence. But I want to hold back some of the fun stuff. I want to introduce the concepts and the themes, but hold back the details. So I know there's lots of people who say, no, you throw your best depo clip in opening, you throw your 5 best documents in opening. And I see that can be very effective. It's just not my style. I want to really roadmap. I want to set the concepts. And I'll tell you, I spend a third to a half of my opening just on what I call an inoculation, giving the jury a little bit of the bad stuff the defendants are going to come up with so they can be inoculated for it. I want to give them the spin to listen to what the defense are going to say. I want to frame the argument the way I want them to hear it. And my hope is when I sit down, the jury hears no new topic from the defendant that I haven't already addressed. And I think that's even more important than selling your own case, is really framing the defense case to give the jury the inoculation, the booster to sort of overcome the disease of the defense arguments.
Yeah, I remember the first time I heard defense counsel get up and an opening and said, well, there's some things Mr. Berger didn't tell you. And I was like,
Yeah.
oh, I'm in trouble.
Yeah. And that's the worst
Lesson
feeling. And of
learned.
course, they're going to find something little,
Sure.
but I want, because you can't always anticipate everything they're going to say, but I want to. And also, by exchanging slides the night before, I use a lot of the defense slides in my opening. I just either recreate them or take them straight. If they send them to me in color, I just cut and paste them. If they send them to me in black and white, I reproduce them. And so they've seen even the defense arguments already, the way they're going to be shown with my voice on top of them. And that's the best part about being a plaintiff's lawyer, is you get to go first. So I get to sort of frame the issue. And I get to give them a way to look at it with suspicion and not just, buy it hook, line, and sinker and it land on them. I want to give them that shield, that armor against the defense arguments. So, a third to a half of your opening should be what they're going to say. And, 2/3 to a half of your opening should be what you're going to frame your case as.
And so when it comes to framing, which I think is such a powerful and critical concept, what do you do in terms of visual storytelling to really hone the jurors' attention in on this frame that you're creating for the case?
Well, I think you have to focus group a lot of frames. I mean, the first frame that you think of is probably not going to be the one you use in opening statement, because as the case develops, the power of your first thought trickles away because it doesn't really match what the evidence is. So, you've got to kind of really not get wedded to something that doesn't work anymore, and not get wedded to something that the defense can spin on you or flip on you. You want to have a really clean frame. But I think also, remember, you're a juror and you walk into a courtroom. You have no idea what kind of case it is, and you know nothing about that industry. So you don't know what the emergency room protocols are. You don't know what trucking rules are. You don't know what it takes to bring a new drug to market. You just don't have any idea. And if right at the beginning there isn't a little bit of education in your opening statement of, look, the rules of an emergency room are, you should create a differential diagnosis, you should see the patient within 45 minutes, you should, whatever the rules are, you've got to lay those out there pretty quick, because otherwise everything you say, they can't understand. It's it's like a Christmas tree. You've got to create the sturdy base of that tree. And that is, what's the right way to behave in this situation? What are the construction rules when you are using heavy machinery? What are the maritime rules when you are a seaman at sea? Whatever your industry is, whatever, it, because probably you do a lot of that work. But the jury doesn't know it. And so I always start with the safety rules. This case is about a trucking accident. This case is about a misdiagnosis in the emergency room. And I spend at least the first 5 minutes just very simply, with very simple visuals, explaining the rules of that industry. And then when I turn to, and on September 4th, 2022, the jury already kind of knows what's coming. Okay. They know someone got hurt because the rules weren't followed. So then you can start matching up your story to the rules you've given them. And you go first, Your rules are simple and clear. They make sense. You're not asking for the moon. You're not asking somebody to, redesign every airplane in the sky. And I think that's an effective way to anchor and to frame your case. Teach the jury what they need to know, then give them a little information of where the case is going to go from your perspective, and then really inoculate against what the defendants are saying.
And so I'm a visual learner too. And one neat thing that I've picked up on just in this podcast is, your body language is signaling where things are visually, which again, as a visual learner, I appreciate, because I'm following you when you're going and the rules they know, and it's giving them this roadmap. I'm moving along with you. When you're giving jurors the safety rules, if the rule isn't just so common sense as to be common sense, are you giving them the source of the rule at that time? I mean, I know you're probably wanting to find rules that speak for themselves without needing a source, but if you come into a situation where you think, I should probably go ahead and tell folks where this rule is coming from, or are you doing it then, or are you saying, well, then we need a simpler rule?
Both. I mean, sometimes you are holding up, the little book that everybody read when they went to take their driver's education test. And you're saying, look, I mean, we all know what the rules of driving, safe driving are. Yes, the speed limit is 55, but not if it's snowing. I mean, we were taught that, the speed limit is not always the same depending on the situation. So sometimes you are sort of citing yourself. You might hold up the manual for that hospital of the protocols. Sometimes you can use a visual to hold on to sort of say, look, this is where I'm getting my rules from. But I really try, and I encourage the lawyers that I teach to try and establish the safety rules during discovery so they are not in dispute. Try and get your safety rules to be so simple that you agree with them, your experts agree with them, the defense agrees with them, the defense experts agree with them. A simple one like stairs should be visible at night. I mean, if you have a situation where the stairs are not visible at night and your client falls down the stairs, everybody's going to agree with the concept that stairs should be visible at night. Now the defense are going to say, but she should have looked more, and she should have looked down, and she should have turned her own, light on her phone on, or whatever their defense is. But the concept stairs should be visible at night is so easy when you lay that out in a deposition. And I do a lot of safety agreements. So I use a lot of agreement charts in opening too, because I've established them in my depositions. In fact, I fight like crazy to do every deposition by Zoom so that I can use a lot of visuals in the deposition where the jury can see the visuals and the deponent. In a live deposition, I'm interacting with the witness, but the jury only sees the witness. They hear my voice, but they see the witness. In Zoom, they see my visual and the witness, right? Because we know as soon as you hit share screen, it's split screen. And if you tell your videographer to record the split screen, the jury will see your safety agreement charts. And when I put the words stairs should be visible at night, yes, no, on a visual, really the manager of the hotel, the security guard, the person who designed the hotel, the owner of the hotel, and the expert are all going to agree, because it sounds so silly to say, oh no, stairs should be really dark at night. You can't do it. It just seems silly. So I try to create easy safety rules, and I really have them hammered down in discovery. So I'll start with 20 safety rules and end up presenting 4 at trial. Because if I find that 6 or 7 of them are really being quibbled with, then maybe I don't need those. They may be something my expert says on the stand as a tag on, but it's not going to be one of the ones I hammer.
Yeah, I love this. This has been already like one of the best episodes we've done. This is one of those times that the movie is even better or just as good as the book. So thank you. Using visual storytelling on direct examination. Tell us about that.
Oh, I do every direct because, first of all, if I'm going to I do mainly long, complex trials. So we're going to have, 4 weeks of testimony. There's going to be lots of witnesses. They don't remember Dr. Smith. So in closing argument, I stop and I say, well, you remember what Dr. Smith said? Well, they don't remember Dr. Smith. So instead, when Dr. Smith takes a stand, I've taken a little picture of him in the hall right before he came in. It's on my slide, or I took it the night before and whatever he was going to wear the next day, his jacket, his coat, his tie, and it's on every slide. And, so when I put up couple of his sentences, or I put up the visual I used with him, his picture's on that slide and they recognize it. That's a really easy way to bring back the testimony, is just thinking sort of ahead. Okay, your expert's going on tomorrow, take a picture of him tonight and what he's going to wear, put it on every slide, and then any slide you choose to use in closing, the jury's seen it already and they instantly recognize who it is. They don't have to stop and think, okay, which doctor is that? My God, there's been 17 of them. So I use a lot of slides in direct because I do all of their resume on slides. I mean, I have a picture of the logo of their school. I have a picture of the Eiffel Tower if they trained in Paris. I've got, them if they're from Australia. I have a picture of them coming, a little map where they came from Australia on a plane all the way to Chicago to come to testify. Things that make it visually interesting as we go through the backstory, who they are, what they are. And then I actually cut every single exhibit I'm going to use already, so that I don't use a tech person at trial, so that I don't lose that momentum of, will you pull up exhibit 179? Okay, turn to page 2, go down to paragraph 3. Okay, no, wait, not the second, third sentence. Okay, yeah, start highlighting from there. What have you done? You've lost the momentum. Whereas if I can just do a little extra work the night before, I say, okay, doctor, turn to tab 1, and I put all of the documents I'm going to use in a 3-ring binder. The witnesses is highlighted. Mine is highlighted. I hand it to the defense lawyer. I hand it to the judge. Theirs are not highlighted. But that means the moment I start a witness, the defense knows every exhibit I'm going to use. And generally, they're tabbed. Sometimes I get a little out of order because I decide to skip, something or move around. But basically, we're just going to turn like this, going through the documents. And I established to the jury that me and the witness met. We went through, we chose out the 20 documents we think best explain his testimony. I'm going to hand you a binder with them. Let's go. Let's talk to the jury about what you thought was important. And with each exhibit, it comes up. I have the logo of the company right there. I have a special colored background that matches their logo. So every time the jury sees that coloration, they know this is an internal company document. If it is my client's medical record, I have a different colored background with a picture of my client on it. And as soon as they see that background and my client's face, they know, oh, this is my client's medical record, employment record, school record. They recognize that I am color coding the evidence to help them immediately visually understand what it is. And because I've cut the documents already, my first slide is going to be the title of the document. I get then the next one is going to be the title really small, and then the pull out of exactly what I want from page 3. And I can move really fast and keep the momentum. I also can move so fast. Often the defense lawyer can't object quickly enough and they give up. There's that moment you ask the key question and the witness pauses and you're like, no, answer, because you're just giving them a chance to think of an objection, get up and break the flow. So by putting all the documents there, so the defense lawyer can't interrupt my flow by saying, I'm sorry, which document, which page, where are you? On my slide, it says page 2. There's the pullout. It's highlighted. My expert starts talking. We discuss it. All right, let's go to the next page. We discuss it. It moves the flow very quickly and it tells a visual story, right? The visual story you're telling is, I'm working really hard to get this story to you. I'm passionate on behalf of my client. I have really thought through what I think is important for you, the jury, to focus on. I'm not wasting your time fumbling around in a box of exhibits, pulling out the wrong one, and I can't find the right one. Everything is there. Everything is on the screen. It's blown up big enough for them to be able to see it. I go to the courtroom the day before we start trial. I sit in every jury seat. I put exhibits on the projector. I make sure everybody can see, or I adjust. I start pulling out more. I start making it bigger depending on what I see in the courtroom. I'm sorry, I'm babbling, right?
No, it's great. So I'm staying out of the way. The question that came to mind for me, so what softwares are you utilizing most frequently for your visual?
I use PowerPoint. It's only because I'm good in PowerPoint. It's what I started with, and I'm good at it, and I'm really fast. And I build all my own slides, which I would not recommend, but I'm very OCD, and I never want a slide to come up that I don't fully know everything that's on it, that I didn't choose everything and place it very carefully. So it's a workaholic's nightmare, because I spend a lot of time. If I'm going into trial, the last month before trial, I'm cutting exhibits. I'm cutting exhibits and making sure I like the way it's placed, the way the background is, the way it looks. Can you see the page number? And I'm trying to envision with every slide, what objection could they make? What could I do? What can I change? And so I really spend a lot of time thinking through what I'm visually going to present.
And moving on to cross, what have you seen in terms of best practices, things that have been most effective for you, visual storytelling on cross-examination?
Very similar. I cut every exhibit I'm going to use in cross. I put blank slides between them, and I write in my notes the slide number that starts that exhibit, because each document might have 5 slides, 4 slides. And so I don't have to follow a certain flow. I can shuffle my notes, as the direct is happening, and I can still find my slides because I have the slide number next to each one. I can just dial them in each time. So I set out, the issues I know I want to handle. I have the exhibits cut and ready. I have the numbers in. But on cross, I think a really nice thing to do is to have an additional visual of a blow up or a flip chart. That allows me to sort of get in the well with the expert, with the antagonistic expert, and build a checklist. So I might stand up at the beginning and say, okay, my understanding is you're really here to talk about these 3 things. And I write the 3 things on the board. And I said, okay, let's start number 1. Your company did nothing wrong. And then I'll do that part of the cross. All the documents that show they knew there was a problem, they didn't do anything about it, they didn't fix it. And then I cross out that point. Your next point was my client did something wrong. And then I move to all those documents. And I can easily jump around in my notes. And I also try, as I create my cross, to put each issue on a different page that's, a 3-hole punch page. And I take them all out of my 3-hole punch binder as they start direct. And I number on the top in red, page 1, page 2, page 3, page 4, as I sort through them to put them in order. And sometimes I start at the end, what they last did. Sometimes I start at the beginning if I have a flow that I want. But that way I can very easily, I see a lot of people that write everything down and then they can't find, but if you put each point on a different page, you can just shuffle them like playing cards. And then you can very easily move around. And if you write your slide number next to the point, you know exactly what slide number to dial in to get to your. I also have every document in a 3-ring binder. And start across, I hand their defense lawyer every document I'm going to cross their witness on. It shows to the jury, I'm not afraid. I'm not here to trick you. I'm not tricking them. I hand it up to the judge. I hand it to the court reporter. I hand it to the witness. I hand it to the other side. And even though we take a break and I know they may go coach the witness on something, I hand it over. And only if I have a really great document do I keep that as a paper copy. So there's usually 1 or 2 that are just in a folder on my desk, and I'm going to use those, at just the right moment. But everything else I lay out so that I tell the jury I'm really confident. I'm here. I'm prepared. I know what I want to say. I'm going to attack him directly on what he said, and I'm going to show you why what he said isn't right.
Are there any additional visuals that you're creating during the defense witnesses direct examination?
Yes, usually like check off boxes. Like if the witness is going to agree with me on 5 things that are important, my client lost consciousness, my client slurred his words, I will make a chart of that, and then I will check off each one of those in front of the jury. So, I might have a blow up that I've gone to FedEx, Kinko's, and blown up just a black and white, chart, or I might write it out that morning, or I might just create a box chart and write it in as I go along. But there is something that really adds emphasis. If you're going to do a 2-hour cross and it's just exhibit, 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 it gets a little boring pretty quick, even if they're really dynamic exhibits. So you want to have exhibit, a board that kind of summarizes, checks off, writes down, emphasizes, reiterates. And then I'll take a picture of that board at the end of the day, and that may show up in my closing with this guy's picture. You know, like remember when their expert came and he agreed with me on these 5 things, and I'm showing the jury without a lot of clutter, because I could go back in closing and try to find it in my flip chart, but now I'm burning my time, right? So I'll take a picture of it and then just throw that picture on a PowerPoint and use it in closing.
And so when it comes to closing, I take it similar or identical to opening. Closing is something that you're working on throughout the duration of the case. By the time that there's the close of evidence, how much of your closing would you say is complete, and how much is still left to do from a visual standpoint?
95 is done, because I'm going to go back and pull out. I mean, look, I want the jury to feel like their time was not wasted, that closing is a surprise. And like, where was I? I didn't hear any of that. I want the jury to see that I called the witnesses I called for a purpose, that I asked the questions on cross for a purpose. So now I'm bringing the whole story together in a synthesis. And I use the visuals that I used during the trial in closing. I pick out the best 2 or 3 slides from each witness, whether that's a visual, a chart, a checkoff box, a document, the pull out of a document, certain words, maybe a very short depot clip. But I'm going to, all that's done. In closing, I may add 5 extra slides just to sort of summarize or pull together something. But 95% is done. It's just bringing back the greatest hits of the trial in the order that makes the most sense. And a lot of that is bringing back some of the opening slides, some of the, because you've used the opening slides at trial, bringing them back again in closing.
And so what do you like to do in closing from a structural standpoint or a sequencing standpoint? What are some of the things that you found to be most persuasive?
Again, I organize my closing very similar to an opening. 2/3 is on what I'm advocating for, and 1/3 is what I think is coming next in their closing, to inoculate, to go back and really have the jury have a framework for what I think is coming. And then, because I've got rebuttal, so I can sort of hold the passion, the rage, the sadness, the anger, for rebuttal. My start of close, my beginning, my opening of close is usually pretty calm, organized. This is why we've been here. This is what I told you in opening, and this is what it is. And I try to weave my story. I try to weave the story and add the evidence to the story. So they've sort of understood the story, but now they're seeing how each piece of evidence, many times I have an image of a windy road with billboards. And I use that a lot. And on each billboard is a word or a phrase. And so as my closing goes, I said, we started this path, this road together 3 weeks ago. And let's see where we've been. And then each billboard will be sort of a topic or a theme. And that allows me to then use a couple of visuals that cement that theme. And then we go down the road to the next billboard and we talk about that theme.
And so what do you do in terms of visuals for the amount of money that you're telling, recommending, sharing, asking the jury that it's worth? What are you doing visually when it comes to the amount on the verdict?
I do not use dollar sign. I do not use pictures of money. I do not use any of those, which I think the jury feels is just trite. The only time the jury will actually hear me talk about the money is I will I blow up the damages question on a big board and I stand with them. And so I've got my visuals going through, okay, let's talk about emotional distress. And then I'll show them some pictures, maybe some videos, some testimony that talk about that aspect of the damages. And then in a marker, I write in the money that I recommend. And if you're in a state that you can do per diem or that you can explain where that money comes from, I may give them that guidance. Obviously, there's some jurisdictions you're not even allowed to do that. You're just allowed to talk theoretically about emotional distress. But if you're going to write a number, I don't like it on a slide. I like to write it because what I'm hoping it does is it makes the jury pick up their pen and write it. We learned in school that when the teacher wrote on the board, we had to copy down what the teacher said. And so
in my mind, I'm going back to my third grade teacher and writing the cursive F on the board.
Correct. Yes. And so if you pick up a pen, if there is, a question and a blank, and you pick up a pen and you write in a number, and you explain where that number came from, what you're hoping is at least one juror writes it down. But if nothing else, it's got a much better chance of implanting not just the number, but the methodology for your number when they see you writing it.
Fantastic. And then on rebuttal, visuals that you like to use on rebuttal.
I usually create about half my visuals ahead of time, and I create the other half as the defendants speak. So I have a format, where I'll have created sort of a specific slide that says what ExxonMobil says, right? And so that's all created. It's got the ExxonMobil logo and then there's a blank that I can fill in as they speak. And I basically sort of create the topics as they do, so that when I stand up and say, okay, ExxonMobil said this topic, and that's there. And then I may have a visual I've pre-created that, butts it, opposition, nulls it, explains it. So I build the framework of my rebuttal ahead of time, but and then I start with a blank slide and I end with a blank slide. I think you have to start rebuttal with an emotion, whatever that emotion is: outrage, sadness, disappointment, anger. You have to stand in front of the jury and express the emotion that is authentic to you. And then you start your rebuttal, and then you end with a blank slide where you can shut it down and, pass the case over to them. And that's really an important time that you look them in the eye and you talk about their duty, their obligations, the honor of having been in front of them. I think that's really important at the end.
The incredible amount of preparation that goes into this is one of the things that stands out for me. And I know it's one of the things you want to stand out for your jurors. So obviously I commend you on all your successes, but one of my big takeaways from this podcast is just the incredible amount of work that has gone into those successes. Zoe, for lawyers who want to learn more about visual storytelling, some books and some sources you'd recommend?
There's lots of great stuff out there. I have a bunch of videos on YouTube. There's lots of good lawyers that have YouTube videos on all kinds of parts of visuals. There's Beyond Bullet Points, which again is sort of the punchline of that is all those words, take them out. They don't work. But I think also you have to play around with it, because you can't just copy someone's visual, because each visual is so unique to your case. And if there's one punchline of everything, is work is magic. The more work you put into a case, the more magic you have in the courtroom. And, your client chose you, gave you the honor to speak for them, and you have the honor of doing that work. And the more work you do, the more you dig in, the more in depth you get, the more you can pull. I call it putting the drone in the air. The more little pieces of blades of grass you paint, the more when you put the drone in the air and look down, you can see the field and the forest. But you have to do every little piece of work in order to put the drone in the air. And I always tell my staff as we're getting ready for trial, okay, it's time to put the drone in the air. Now, after all these months, all these years, what do we have? What's our 10 best things? And, we have 30 things that we love because we spent a lot of time and money developing that get cut. When you put the drone in the air, that pattern doesn't show up. That is not a forceful, strong image that you want to carry through. When you put the drone in the air, sometimes it amazes you that the stuff you spent so much time fighting for and having all these hearings and getting the judge to order just isn't making the cut. The image isn't there.
Work is magic.
Work is magic. And what we do is alchemy. What we do is we weave liability with causation, with damages. We look to a fact witness that knew my client before and after. And their testimony is, yes, great on damages, but also great on causation. This woman was like this, and now she's like this. And the only thing that changed is this drug, this accident, this incident. So each witness has a bigger role than just, the pigeonhole that some people think of. So it's alchemy. It's also seeing how can you plant medical causation in liability. How can you plant liability in damages? How do you weave that story to where it's a cohesive story? Work is magic, and what we do is alchemy.
Amazing. Zoe, for folks who want to get in touch with you regarding visual storytelling, regarding trying cases, you trying cases, what's the best way for them to do that?
Email me, Zoe, Z-O-E, at littlepagebooth.com. I'm Zoe Littlepage. My law firm is Littlepage Booth. And because we live in different, we live sometimes out of the country, we live sometimes in the country. I work all the time, but from different places. So it's always easiest to email me because I check my email kind of religiously.
And so the last thing that I want to talk about is you're also part of a law firm with some of the other leading female trial lawyers in the country. Will you just tell us a little bit about that and any special words for the female trial lawyers out there?
Yes. So in the pandemic, we created Athea Trial Lawyers, which is 6 women. We all have our own firms. We all have had tremendous success and joy in our careers. And we came together because we wanted to try cases together. We wanted to collaborate. We wanted to brainstorm. And it's miraculous. I mean, each one of us has a different skill and strength and talent. We share generously. We love our Zoom calls where we present a case and then we get, some of the most creative minds talking about it and giving us ideas. So if you have a case that you're struggling with, you have an image you're struggling with, you're not sure exactly how to frame something or visualize something, email me. And next time the Athea women get on, I'll say, okay, I got a case for you. What do you think about? And they come up with, it's incredible when you put 6 brilliant minds together and, 100 years of trial experience. They come up with stories, analogies, allegories, visuals that you would not have thought of. And as soon as they say it, you go, oh my God, that's so good. It's like a focus group on steroids. And it's been really fun. We've managed to try cases together. Not often you see all female trial teams, and we've had really good success. And the jurors have really responded to all female trial teams.
It's incredible. Listen, thank you. I'm very grateful for you taking time. You were also kind enough to work with me once when I needed to reschedule, which was very generous of you. And this is wonderful. I look forward to one day meeting you in person, and we'll continue to admire the work that you do. Ladies and gentlemen, this has been Best Practices with Kenny Berger, our guest today, Zoe Littlepage, and we look forward to being with you again soon. Take care.
Thank you, and go find joy in the courtroom.